My name is Anjali Kauster. I am the CEO for the Cupertino Chamber of Commerce. Our topic of discussion today is legal challenges for reopening businesses. With us, we have Rich Abdallah and Rob Noodleman. Rich Abdallah is the owner and principal attorney at the Abdallah Law Firms in Cupertino. He has over 35 years of experience in employment, real estate, and business law. Robert Noodleman is the owner and primary attorney at the Noodleman Law Firm. He represents individuals and companies in federal and state court and before various administrative service agencies. Now, before we get started, I would like to remind everyone who is joining us today to please write your question in the question and answer tab, and we'll do our best to answer them live for you. With no further ado, I would like to turn it over to Mr. Abdallah.
All right, good morning and welcome everyone. I hope you get some information from this presentation that will help you. I want to thank Rob, my co-presenter in this situation or in this presentation. Rob has done many presentations and I've attended most of the ones or many of the ones that Rob has done, and he's very knowledgeable and a good presenter. So I think you're going to get a good body of information. The one thing I think I want everyone to understand is that what we say today may change tomorrow, meaning that this situation that we're in, not only in our country but across the world, is so fluid that what we are telling you today, you need to kind of follow up with online information a week from now or whatever, because it will be changing. What Anjali and Rob and I decided to do was to focus on some questions that Anjali had put together for us. So I'm going to read a couple of questions, and those questions that I will address will be primarily from a business owner standpoint. Rob will address a little more of the employer-employee interaction, which I think is much more difficult. Because frankly, the employment laws in California are complex and there are many of them. And once you make a mistake, if you will, you can't unring the bell in many situations. But so the first question that Anjali suggested was, how concerned should a business be about possible legal challenges once they reopen? This may sound obvious, but obviously you need to be very concerned. And what the business needs to be concerned about is what do I do if I have a business where people come to my premises to obtain services or products? That's one situation. And what do I do if I have my clients or my employees rather go out from the business and have contact with third parties, other businesses or consumers, if you will. So those are going to be two different areas of concern. At this point, I think the best thing for a business owner to do is to become as familiar as you can with the federal, state, and now local guidelines, which are significant number regarding what to do with customers, vendors, or visitors who might become infected and risk a claim. I would say that if you can follow the federal, state guidelines, local guidelines regarding how to address the issues that relate to the COVID-19 situation, that's your best route right now. I mean, there's no other source for information, frankly, in the sense that, as Rob and I will talk about later on, I mean, obviously, you're going to have quite varied situations. I go to McDonald's every day and get my coffee. I'm in there for 3 minutes. Now I'm not even in there, right? I drive by. If I get sick, and thank God I haven't so far, but and I want to try to blame McDonald's for some reason or other, kind of hard to envision that, but they're a deep pocket, if you will. It's going to be very difficult for me to say that, gee, I was exposed for 2 minutes, every day to somebody who passed me coffee out the door or out the window. as contrasted with a business like Rob's and mine, where consultations sometimes take place in person more often before than now. And sometimes those consultations can take an hour or 2 hours or 3 hours. Same thing for a CPA, financial advisor, maybe even an insurance agent. That face-to-face contact is pretty important for us to build trust with the client or customers, the case may be. So we might spend quite a bit of time with them face-to-face. Now, of course, we're looking at doing more over the internet consultations with clients. And given that we're all kind of in the loop on using the internet and using these forums that we're using, Zoom webinar is certainly one of them, I think clients are a little more comfortable. Some clients absolutely do not want to come in to visit you, and some clients would like to see your face and just interact with you. Typically, if a client has been with you for a while, that's not so important. So the recommendation I have at this point is to consult with someone or to review with someone the laws that are on the books right now, varying from state to state, federal laws, as well as local laws. It's kind of a little unusual to have that many layers of of regulations, laws, and statutes, but right now that's what we have. The next question that Anjali suggests is, what about customers who might claim they contacted COVID-19 by visiting a business? What does a business do in that situation? My recommendations would be somewhat similar. And in other words, it depends a little bit on the nature of the business and what you may be required to do in order to protect the public will vary to a degree depending on how you provide your service or your product. I'm particularly concerned about clients who send people out to do business in the community, such as a plumber or someone who does business on site for the customer, maybe a homeowner or maybe a business. That could be a little more problematic for you as a business. Obviously, one of the things you need to do is have your service providers wear masks and follow other routines. Rob is going to cover, well, do I as an employer have the right to require my employees to have their temperature taken every day, et cetera, et cetera. So that's a whole basket of issues that he's going to cover. The common approach, and I'm going to turn this over in a minute to Rob for some other questions, a common approach or claim that you can expect from, let's say, a customer or a client if they were to contract COVID-19 and want to claim or wish to claim or feel they should claim that was caused by the negligence of the service provider or the product provider, is just that, negligence. And you've heard that term, I'm sure. We probably all have heard it in connection with automobile accidents, for example. And the general definition of negligence is failure to exercise a standard of care a reasonably prudent person would provide. Okay. The problem for us as attorneys and members of the public is there is no standard of care that we can look to in this COVID-19 situation. So we're kind of making this up a little bit as we go along. Again, I would go back to make sure you try to understand what impact the state, local businesses, statutes and laws may have for your particular business. So I can't give you any kind of bright line that if you do these two things, you're fine. If you don't do them, you're at risk. So I'm just going to leave this subject and turn it over to Rob for the next question. But again, there's only one thing I can suggest or recommend, and that is to try to do your best to understand the state and federal guidelines on the subject matter. Okay, Rob, your turn.
Yeah, thanks, Rich. And I want to kind of, in some way, echo what you're saying in that we don't have a standard, but there are some resources. Sometimes it's almost too many resources out there when you're looking at, everything on, CDC website. I'm going to share with you, this is actually from the CDC's website on what employers can do to prevent transmission among employees. And it has a number of different suggestions. And how do you maintain a healthy business operation? I think getting that checklist, if you can't see it, if you go to cdc.gov/coronavirus, there's a lot of different resources that you can take a look at. And what I like about that is it kind of sets what is the best practices. And it's both as a business owner as well as an employer on what we should do. And some of it's a lot of makes sense. It makes sense in things that we're talking about. Wash hands, have people wear face masks, maintain social distancing. How do we want to do this? The issue of, what do we do if somebody blames the company for getting sick? From an employer-employee perspective, Governor Newsom actually took care of that for us. He created or issued an executive order saying that if you worked and you became sick, presumptively work is the cause of you getting COVID-19. And this is specific to COVID-19. Now, normally workers' comp already covers you if you get sick as a result of work. So if I went to work and I show that I got the flu because I was at work, that would be covered by workers' compensation insurance. The difference is Governor Newsom has created that is a presumption that is what's caused you to get sick if you were working and you got COVID-19, whereas normally the burden would be on the employee to show that I got it from showing up at work. So one thing I would do, I would certainly look at my general liability insurance, and I would look, what does that cover? Because insurance can be a form of what kind of, that's just what it is. It's insurance. How do we make sure that we're covered if something happens? Mm-hmm. And then I would also publish, I would come up these are our protocols to keep our employees and our customers safe. And that's going to be different from business to business. I have some businesses that are home care agencies, and they've not shut down this whole time. So they've had to create protocols. But what do? Some care agencies, for example, are sending out a release of liability saying, hey, if your care recipient gets sick, that's not our fault, and you're going to not hold us liable. I don't know whether or not that's how enforceable that will be. And I think a better tact would be to send something to the customer saying, your safety is important, our employee safety is important. These are all the things that we're doing. We're maintaining social distance. If anybody is sick, we're going to make sure that they don't come in. And we ask for your cooperation. So if you please monitor your health. And if you have a fever, or if you have a stomach ache or diarrhea, or any of the COVID-19 symptoms, let us know and we'll reschedule. So that what you're doing is you're creating an expectation, and you are letting people know that, hey, no matter what we do, there's always a risk of infection. So now if the customer still decides that they want to use your services, they are assuming the risks, which is one of the defenses that we can use, that, hey, this is an assumption of the risk. You can't sue us because you knew that those risks were there. And also it helps assure people, but you have to follow those protocols. So if you're going to tell people that we're going to disinfect the office, you have to disinfect the office. If you can limit your customers coming in. And a lot of things that you're doing to keep the customer safe is also what you're doing to keep the employee safe. We're maintaining those social distances. We're wearing a mask. We're making sure there's hand sanitizer. We're making sure people can wash their hands. I would, like in the employee break room, I would take out the food. We're not bringing in baked goods every Friday that we're sharing and just leaving out on the counter. If people want to bring their food, that's fine, but they should store them themselves. So it's small little changes like that can really help prevent the spread of the virus. Well, I'm going to talk a little bit later on about when we do open that up, how's that going to work? Now, one question is, what do we do for monitoring health? And there's the employees as well as customers. Customers, I don't really think that you can do anything to monitor. I certainly would not recommend taking the temperature of your customers, except in specific instances. I went to the dentist the other day. My dentist is now open, and he has a whole system and because their industry has set these standards, and because the nature of a dentist is he's down looking at my mouth, and he's a medical professional, it makes sense. He gives me hand sanitizer, he gives me a mask, I have to put that on, he takes my temperature. He has this little thing that he sprays me down full of chemicals that make sure I'm not disinfected and all these different things. Gives me some hydrogen peroxide to swallow, or not to swallow, to rinse with. So because it's a medical firm, okay, now that makes sense that he's going to take my temperature. Generally speaking, I would not take temperature of customers. I also wouldn't even take temperatures of employees. I would ask that employees self-monitor themselves on a daily basis and that they take their temperature on a daily basis. I always like to remind people that 98.6 is not your average body temperature. That is the average human body temperature. You may run hotter or colder. My average body temperature is 98.3. So if I'm running at 98.6, that may be an indication of I have a fever, or 98.9, whereas Rich may run at 99.7 because he's just a hot body. I don't know. So just keep in mind, asking the employees, check your temperature every day, preferably at the same time of the day. Let us know if you experience any symptoms. Here are the symptoms: coughing, sneezing, stomachache, diarrhea. Let us know. We have paid sick leave available. We don't want you to come into work if you're sick. And I do recommend that you follow the CDC and the public health guidelines, that if somebody is experiencing symptoms, they need to be they need to be symptom-free for at least 72 hours. And some public health agencies, by the way, say 72 hours. Some say 14 weeks. So there's not consistency as far as that goes. So I would check, as Rich mentioned, there's the CDC guidelines, and then each county has their own public health department, and their guidelines are posted on the website, and they're actually pretty good. If you call them up and say, hey, I have this issue, because I have some clients that have had employees that have been exposed, and we call the public health. What do we do? Who do we need to notify? And depending on the situation, different protocols get put into place. Rich, I'm going to turn it back over to you. Talk a little bit about some of the new safety guidelines, and what do we think? You think this is going to be a lot of new lawsuits that are going to happen from consumers, from employees? What are your thoughts?
Yeah, well, let me ask you a couple of questions that came out of your presentation. If an employee reports to the employer that, hey, I've been diagnosed with COVID-19 and I need time off, does the employer, in your opinion, have any obligation to notify other coworkers?
They do, and they do, but there is a process and a protocol to do that. So step number one is you ask, hey, when did you first experience symptoms? Do you know where you were exposed? And who did you have contact with over the last 7 days, whatever it is? You're sort of gathering information. You are then going to, you would also ask the employee, of course, do you have a doctor's note that says you need to be quarantined? Hopefully they will. The employer should then contact the local county public health department. Say, I have this employee, this is what they've told me, these are the symptoms, they've been diagnosed, what do we do? They will tell you, the public health department will tell you, okay, you need to quarantine everybody, you need to reach out to everybody, you don't have to, because there are different settings, because the fact that I have an HVAC technician who may have been exposed, but has had no contact with any of my other employees, that's a difference. But they may have had contact with customers. I have to notify the customers, but not necessarily the employees. Versus if I have a grocery worker in my grocery, if I have a bagger and he's had contact with all the different employees and all the stock, I may have a higher obligation or more to. So I would defer to whatever the public health department tells me to do. That way also, I'm doing what they say and I'm not having to disclose confidential information. Keep in mind, employee medical information is confidential. So if you do inform people, you do not identify who the person was. You just say in general terms, we've been informed that somebody working for the company may have been tested positive. These are our recommendations. If you need time off, go get tested, etc.
Well, let me follow up with another question, but along those same lines. The employee comes to you as the employer and says that I have contracted the disease, or my family has it, and you think, well, gee, he's been here or she's been here and they may have spread the disease. But do you think that when you're told by an employee that that employee has contracted the disease, that do you have an obligation to automatically notify your workers' comp carrier, even though your employee may not consider that as a workers' comp type of claim? What do you think the duty of the employer is in that circumstance?
Yeah, normally before this executive order from Governor Newsom, I would say no. But because of this executive order, and by the way, I don't think legally he can do this through an executive order, but I don't want my clients to be the one to challenge that. So with that executive order, I would say, yeah, if one of your employees says, I've got COVID-19 and they have been working for you, you say, well, I don't know if this is work related or not, but here is our report of injury form. Please fill this out and we will submit that to the insurance carrier. If they say, no, I didn't get it from work, I got it because I've been taking care of my cousin Susie and she's been sick. You've given them the paperwork. If they decide not to pursue it, that's up to you. But your obligation, anytime you have reason to know that somebody may have been injured at work or suffered a work-related illness, is to provide them that report of injury form.
Do you think the employee has, if the employer has an option, if the employee doesn't claim that they got sick on the job, as opposed to, gee, I'm sick, I don't know where I got it, and I'm gonna need to take some time off, and they don't mention anything about contracting the illness at work, do you think the employer still has an obligation to assume it's a potential workers' comp claim and report it? Or do you think you can just say that will be sorted out at some time in the future? How do you think that works?
I am differentiating between somebody being sick with COVID-19 versus not sick. If it's not COVID-19, I'm not worried about it. Because then the burden's on them. If it is COVID-19, then I think you say, well, to the extent it might be work related, here's a work report of injury form, fill that out. I don't know that I would contact the carrier and report it, because that's up to the employee to file the claim. We've done our obligation. I don't think it hurts to contact the insurance carrier to say, hey, just let you know somebody got sick. They didn't say it was work related, but I gave them the report of injury form. I'll keep you posted. That way you're keeping them apprised. I don't think that hurts, but I don't know that you're obligated to report the injury if the employee never files or indicates that they're going to file a claim. But you do have an obligation to give them the report of injury form.
Okay. All right. I guess the other question might be, and we're not, neither you nor I practice workers' comp, but is it going to be covered by workers' comp, that kind of injury?
Yeah, it will be. I mean, so even before COVID-19, if I got sick because of work, and it has to either arise out of work or occur during the course of my employment, it's a work-related injury. I have had workers' comp claims. I've done workers' comp claims like way in the past, but I don't do it now. But we had a workers' comp claim where somebody got sick because he was traveling on an airplane over to Europe. And it was pretty clear that's where he'd gotten sick. And it was a valid claim. It is difficult because with the virus, it's hard. Where did you really get it? Did you get the bug before? Did you get it after? In this case, he was healthy, traveled to Europe only for work, and then traveled back and got sick on the way back. So it was pretty obvious that it was while it was work related. But now with the executive order of Governor Newsom, there is a
presumption.
The starting position is if it's COVID-19 and you performed work, it's work related. It doesn't mean it will be covered. It could be determined that no, there are other factors and so it wasn't, but it starts with the presumption that it was.
Okay. All right. I'm going to talk a little bit about a question that Anjali suggested. Businesses that reopen have a long list of new safety guidelines. Do you expect this will lead to a surge in frivolous lawsuits over something like a lack of hand sanitizer present or another customer not wearing a mask? Well, first depends on how you define a frivolous lawsuit. We as lawyers never file frivolous lawsuits. I'm sure the public doesn't quite see it that way, but yes, I do think that this is going to be a lawyer's who does personal injury kind of with their dream situation. And I don't mean that to sound positive. I mean, yeah, there'll be an enormous amount of litigation by customers and clients, I think, that want to seek recovery for medical coverage or whatever, or loss of wages that may be due to an illness. So then I think the question becomes, well, as an employer, do I have insurance to cover when there's a claim made against me in a lawsuit saying I got sick on the job, or pardon me, let me clarify that. As Rob talked about, if an employee claims they got sick on the job, it'll probably be covered by workers' comp. There are exceptions where the employee can pursue beyond the workers' comp coverage, but that's not something we really need to cover today, and it's not particularly relevant. But employee sues, pardon me, a customer or client sues your company claiming they contracted COVID-19 doing business with you. And so your first question is, well, they're claiming they have $500,000 in medical damages, loss of wages, mental distress, et cetera. And they're claiming I didn't follow the federal or the state or the local guidelines. And as a result, that exposed me unnecessarily to this disease. And, my analysis of insurance is it's a very specialized area of practice in terms of whether or not a particular policy covers an injury. The other thing that I've learned over the years is that although policies may look identical, they're 10 pages long, and the first paragraph talks about coverage, and the other 9.5 pages talk about what's excluded. They all look alike to us, if you will, as ordinary consumers, but they are different. There is language in these policies that vary from carrier to carrier. So that's one issue. What I think will happen is similar to what happened with toxics 20, 30 years ago. When we sort of discovered that companies were allowing gasoline, oil, or other toxics, dry cleaners were letting poisons go into the ground, not intentionally, but perhaps negligently. What would happen is you'd get this lawsuit, and then of course 9 out of 10 of the times the carrier would decline the claim, and then you got into a battle over coverage. And what eventually happened was the older policies were ambiguous enough to possibly include toxics, and therefore some of them had to pay off. But as soon as the insurance industry found out that these claims may exist or were about to come into play, they started looking at their policies and started changing the language to expressly exclude toxics. Now, what I say that because I think that's what's going to happen here. There may be policies out there that your property policy or your personal injury policy that you have on your business that may have some ambiguous language in it and may possibly cover injuries that are claimed to be as a result from COVID-19. I assure you they are already looking at their policies today and figuring out, well, the next time we send business A, B, or C a policy, we're going to change this language. One of the things that the industry is supposed to do is to advise you when there has been a change in coverage. So, maybe you'll get notice that new policies exclude coverage for pandemics, for example. But the problem for us as consumers of insurance is that we don't have the ability to negotiate those terms. If company A wants to have coverage terms a certain way, you either take it or leave it. There's usually no negotiation. And of course, as I say, policies will vary from company to company. So the question is, will I have some protection if I have a particular situation in which customers spend a lot of time with my employees and I have more than one lawsuit or even one lawsuit? Will I get coverage? I think the answer is going to depend on the policy. I don't know if pandemics are generally excluded, but insurance coverage is a very specialized area. When I have an issue regarding coverage, I refer it to a specialist in that area. So I think, and Rob, tell me what you think, that I think there's going to be litigation over whether there's coverage or not for these general property/liability policies that most of us have to conduct our business.
Well, I definitely think there's going to be litigation. In fact, I already know that I think there was a I think it wasn't actually McDonald's or some other fast food restaurant where a lot of people got sick, a lot of the employees, and now there are a lot of the consumers saying, well,
Yeah.
then I must have gotten sick there as well. You know, that kind of on the same lens, that I'm interested because I know you do a little bit of real estate stuff. What do you think about people's ability to modify or get out of leases or other contracts because like a force majeure, like a force majeure is, well, you can explain it, Rich. You're
Okay.
probably more on that.
Yeah, I have a whole section on that. So let me cover that after I give you a chance to answer the couple more questions
Sure.
on the employer-employee situation. And Anjali wanted to ask about legal issues that we as business owners may face rehiring employees. Do we have an obligation to rehire any particular order, et cetera? So I'm going to turn that over to you, and I will
Sure.
cover very specifically the question that has come up in my practice about, can I get out of this lease? And if so, how do I go about it? But
Okay, yeah, we'll come back to, so the legal issues that you're looking when it's time to rehire, right? We're bringing people back. Maybe we've done a downsizing, we did layoffs, furloughs, however we want to call it. What do we do when it's time to bring people back? First of all, understand, for most people, it's not a floodgates. It's not okay, everybody's back to work exactly what they were. For most people, it's a phase in. We're doing it limited. Number one, like Richard mentioned in the beginning, look at your state, your federal, and your local rules. I'm in Alameda County, so we have slightly different rules in Santa Clara County. We've got different rules than Mariposa County. So know what your county rules are, what they're going to allow, what they're not. I would encourage you to think about things in a phase-in perspective. Do we bring everybody back? Do we do shorter shifts? What can we do to maximize and ensure that we're doing that 6 feet of social distancing, limiting the number of employees, limiting the number of customers that are coming in? How are we going to schedule things? To the extent possible, if you can still have workers working from home, do that. I mean, that's probably your safest bet. And maybe they're not working 100% at home, but they're working some hours at home and some hours in the office. So it doesn't have to, again, be an all or nothing. There's another document I want to share. This comes from again, from the CDC, and it talks about the top tips to protect employee health. And so it's the same kind of things we talked about before, is making sure you have a plan in place to ensure that employees are being safe. Now, one of the issues actually I've gotten a lot is it's time to reopen. I'm ready to bring back an employee, but my employee says they don't want to come back to work. How do we handle that issue? And I've developed kind of a multi-tiered process. So you call up an employee and say, ready to come back to work. And the employee says, you know what? I don't really feel comfortable coming back into work. There still is the shelter in place. You've reviewed your shelter-in-place order, so you know that, well, yeah, but we are an essential business and we're allowed to bring back workers and we'd like you to come back. I just don't feel comfortable. So step number one is we have to find out, is there a medical reason for this or some other reason? So I ask, do you have a doctor's note or is there some medical reason you're not able to come back to work? Because if they say, yeah, my doctor's saying I don't come back to work, that's an entirely separate issue. Now we're dealing with accommodations and possibly with the emergency paid sick leave. Or if they're saying, no, it's because I have to stay home to take care of my child. Again, there are new laws dealing with Expanded Family Medical Leave Act that may require you provide paid time off for somebody who's caring for the child. Or if they may say, I'm anxious about coming to work. Anxious or anxiety, I'm a little concerned about because anxiety is a medical condition. Me feeling anxious isn't, but it's enough that again, if somebody says I'm feeling anxious, I would ask, do you have a doctor's note or has a doctor recommended that you not come back to work? Let's assume the answer is no, and they're just saying I'm generally concerned about coming back to work. We would then go through with the employee, hey, this is everything we are doing to keep you safe. The social distancing, hand sanitizer, limiting the customers coming in, whatever is our plan. And you're going to talk with the employee about that. And you say, having told you these things, do you still feel uncomfortable coming to work? If they say yes, then you ask, is there anything we can do so that you will feel comfortable coming to work? If they say yes, find out what it is. Maybe there's something you hadn't thought of, It's like, oh, you want just a face shield? Let me get you some face shields. Or, oh, you want me to put up a plastic barrier between the receptionist and the people coming in? I can take care of that. Let's do that. But assuming you've asked them if there's anything you can do and they say, no, there is nothing you can do, you should not force employees to return to work if they're feeling unsafe. So I would say, well, if you're not going to come back to work, then it's not going to be a paid leave of absence, and you probably are not eligible for unemployment insurance because there is work available, and there actually is a pamphlet you can get from the EDD about fraud, and if somebody is not reporting that they were offered a job, what could happen, and you may want to provide that to the employee. Sometimes that's enough to convince them to come back to work. Sometimes like, no, that's fine. I'm just not going to come back to work. And then you have to decide, what am I going to do? I would you need to hire somebody to do that job. I'm not saying I would fire the person, but because they're saying that, I would tell them, when you feel comfortable coming back to work, give me a call and we'll talk. I would, however, treat it as a separation of employment, such that if that person has any accrued vacation and you have not already paid that out, I would pay that out. A lot of employers, we're going to see a lot of litigation, I think, in employers that furloughed people but didn't pay final wages. In California, you have to pay employees all wages earned immediately upon termination, including any accrued vacation. And if you furloughed somebody where you reduce them to 0 hours, the labor commissioner takes the position that that is a termination. Unless you've given them a specific return to work date within the same pay period, that is a termination, triggering your obligation to pay. And that triggers penalties under what we call waiting time penalties, that are the employee's wages continue for up to 30 days. So you could unintentionally have created that liability. I think we're going to see a lot of those claims coming through. We'll see what the labor commissioner does or the courts do on that. I know, because I represent employers, but I also represent some employees, I'm getting a lot of those inquiries. So we're making sure we're maintaining a safe workplace. We're communicating with the employees about what we're doing. I would try to bring people back at the previous pay, but sometimes we have to change that. Sometimes we can't bring somebody back full time. I would want that to be clear. When they're coming back, I'd say, look, we're having to reduce your wages to this. This is your new pay rate. These are your new hours. We're hoping that it's going to change. Hopefully we can bring people up to full time. I err on the side of giving more information to the employees so that they can make an informed decision. Keeping in mind, if somebody decides not to return to work because you've lowered their wages, they may or may not be entitled to additional unemployment benefits. By the way, fighting unemployment benefits rarely makes sense for most employers. If you are inclined to want to fight the unemployment insurance, talk to your legal counsel. More often than not, that smart plaintiffs' attorneys will use the unemployment insurance forum as a basis to create the wrongful termination lawsuit and get information. So just be cautious, and it doesn't usually cost that much. You do want to make sure, of course, that you have appropriate protective equipment, the PPE that we hear about. What is appropriate for your workplace is going to be different than what's appropriate for mine. Do you need face shields? Do you need gloves? Do you need, what is it specifically you're going to need? Do you need full body suits or, hazmat? It depends on your circumstances. Again, looking at the CDC websites and the public health department websites, think about what can we do? How can we move some things around the office to make sure that we have wider space for people to go by? Oftentimes you'll have that secretary's desk that's right in the middle, but if we just move it over 5 feet over this way, now we've got, and people can walk down the hallway without coming in within 6 feet of them. Think about those kinds of flow. Think about, okay, we're just going to go ahead and we're going to unplug the refrigerator and we're going to open up because we don't want people storing their food there. If somebody wants to bring their stuff, they can keep it in their office. If you have not already purchased Zoom or Blue Jeans or Skype or whatever, that's something you're probably going to want to do if you haven't been doing it already. Just because people are in the office doesn't mean you have to have all the meetings have to be in the office. I'm starting to see more and more clients, but I'm still doing most of my initial consultations over the phone or via video conferencing. It's safer that way. So those are kind of the main ones. Now, there are some new laws that employers do need to be aware of. when coming back to work. We mentioned the workers' comp, the presumption there. As far as wage and hour laws, I mentioned that issue of was this a furlough or was it not? When you are changing, if you have to change somebody's wages, if they're salary or hourly, you can do that, but you can only do it prospectively. Meaning I can't wait for you to work a week and say, oh, by the way, now we're reducing your wages for the work you just did. I have to tell you ahead of time. My preference is tell them at least a week or at least a pay period in advance if you can. Sometimes you can't, but you certainly should tell them before you start. And that includes commission agreements. There are many people are paid by commissions, and we're wanting to change that because our business is slow or we have to make modifications to adjust. You need to make those changes before the commissions are earned, not after they're earned. So communicating with that, preferably putting those things in writing. We're going to see, keep in mind also during this COVID-19, a lot of different minimum wage laws in different counties has changed. A lot of them, July 1st is the date that the new higher minimum wage goes into for a lot of the local ordinances.
Mhm.
So just keep that in mind when you're bringing them back. If you were paying your employees minimum wage based on Sunnyvale's minimum wage law or Santa Clara, that Berkeley, I think, changes July 1st, just that those changes are going to take place. Oh, by the way, if people do want to ask questions, because we've got about 20 minutes or so left on our presentation, use the Q&A section. You can put your questions in there, and Rich and I will try to, and Anjali will try to help prompt us, and we'll try to address them as we come.
Okay, Rob, I have a couple of questions on, one, do you think an employee has a right to demand that they be allowed to work from home? And if the employer says, no, that's not going to work for this company, do you think that's considered a, as far as eligibility for unemployment? Maybe those are two different questions, but I want to.
Yeah, it's actually four questions because it depends. As any good lawyer answer, it depends on why they're demanding it. So even prior to the COVID-19, if I have a medical condition, a disability that requires an accommodation, one possible accommodation is working from home. So those laws existed, those laws continue to exist aside from the COVID-19. That's why when somebody says, I don't want to come into work, we need to ask that question of why. Because if they're saying it is a medical condition, then we have to go through an interactive process to figure out, is this reasonable? Is there something we can do? Is it not? Because working from home can be a reasonable accommodation. One issue that comes up with this is, let's say you were performing your job well prior to COVID-19, and we allowed you to work from home during the shelter in place. I now want you to come back to work, and you're saying, well, I have this medical condition that requires me to work from home. And obviously you can allow me to work from home because you just had me working from home. That's not necessarily true. Some employees are just as productive working at home or more productive working at home. Others are not. Some jobs you can be more productive. The fact that an employer temporarily allowed an employee to be less productive and work at home doesn't mean that they're obligated to continue that forever. But again, you have to ask that, is this medical? If it's not related to a medical condition, then you're in a much safer place to say, no, you have to come back to work. The only other exception is there is that Families First Coronavirus Response Act, part of which there's 6 different reasons that people could be entitled to emergency paid sick leave. And one of those, most of it's for only 2 weeks, but there's one way they can get it for 12 weeks. And that one is if they can't work because their child, their school or their child care is unavailable due to COVID-19. The fact that schools are on summer break, that doesn't apply. But if normally I would send my child to child care and that child care is closed down because of COVID-19, then that might apply again. So that's why it's important to know, why are you not wanting to? If they're just saying, no, I'm concerned and I don't feel safe, we go through that process of, this is what we're doing to keep you safe. Is there anything else we could do? And if not, then you say no. And then if they file for unemployment insurance, it's up to the EDD to decide. If the EDD contacts you, you will let them know, yes, we had a position available. We went through all these things and they chose not to accept it.
Okay. All right. I want to just touch on a little bit on what you mentioned before, and that is, how can you get, can I get out of my lease as a business employer because of most people have had to shut their doors for a period of time, and it's been horrific in a lot of cases. So is there a way to get out of my lease because of the pandemic? In general, the answer is probably no, except it will depend on the nature of the business that you have. And therefore, you need to have, advice about your particular business. I have one client where the business has to be done on the premises. It's the nature of the business. They can't really do Zoom because the customers aren't interested in Zoom, and the employees who provide the services don't want to interact with the customers face to face because of the potential for contracting this disease. So that's an issue, but there's this thing called, I'm going to call it a thing, force majeure, and it's often included in leases. This is a provision that essentially allows a tenant under certain conditions to avoid certain requirements under the contract, but rent usually isn't one of them. And it's usually also not framed in such a way as to allow the employee to unilaterally, the tenant to unilaterally walk away from the lease agreement. A couple things to say, not every force majeure, or however it's pronounced, majeure provision, they're not all the same. There's not a boilerplate. They're frequently similar, but they're not always identical. So they need to be looked at individually. And it's pretty rare that the provision would allow, on its face, would allow an employee, I don't know why I keep saying that, tenant to walk away from a lease. It may excuse the tenant's performance of certain provisions under the lease, but rent usually isn't one of them. There are exceptions, as I've described, but it would have to be done on a case-by-case basis. Whether or not it will be treated, these provisions will be treated very restrictive. In other words, they will be construed in a strict manner by the courts. I don't know what's going to happen. It'll probably depend a little bit on the particular judge you get, but it's not a walkaway clause just because there's a pandemic. You have to have other situations. You have to have other factors that might come into play. And I would imagine too that lawyers who are writing these leases in the future will tighten these things up a little bit more. So before you abandon a lease premises, please consult with somebody. As I say, just because you walk away from the building doesn't necessarily mean that the landlord that then has the obligation to relet the premises, because sometimes it can't be relet because the tenant has not expressly indicated to the landlord that they're leaving, or the tenant may have made it impossible to relet because they've left something or some things on the premises that haven't been removed that make it impossible to relet it. So just have somebody who has knowledge in these areas of contract interpretation, lease interpretation, take a look at it before you decide whether or not you have a right to maybe not pay the rent or comply with certain other provisions. That's kind of what we have this morning. Anjali, I'm going to let you kind of take over on the question part, and then I'd like to wrap it up a little bit at the end.
Sure. I just had a question for you, because we have a lot of in our community, we have a lot of besides restaurants, we also have a lot of childcare, education related kind of businesses. So how do you, when you say if the employees can come back or cannot come back, and with children involved, is there special rules or different rules that they would have to follow?
Not particularly. However, you give a perfect example, in my opinion, of a situation in which the company can't conduct business. I mean, the kids have to be on site in order to provide childcare, and very few parents are going to, probably no parents are going to allow their kid to go to a childcare facility at this point in time. if that's what I do as a business, and that was the nature of the business identified in the lease, it may be impossible for us to perform the obligations under the contract. And that may be, but I don't want to say this as a general rule, that may be grounds to try to seek to nullify the lease.
No, I want to touch on that just because I do have a couple clients that do both childcare, and then we've got also some that are education, like tutors and stuff like that. And the childcare companies are now starting to be able to be open up. It is county dependent, depends on what your county says. And there usually are restrictions and limitations. You can't have more than, I think it's 12 children. You still have to maintain appropriate protocols. So you're still going to be doing those same, going through what do we need to do to keep things safe? How do we do things? And again, I think that is where it makes sense also to send out a letter to the parents. Hey, this is what we're doing to keep your child safe. This is what we want you to do. Let us know if somebody's sick. If they've got the sniffles, even now it's more important than ever that they stay home. If they come in and they have the sniffles here, we're going to set them and you got to come pick them up because we can't have that. And, how are we cleaning? How are we washing hands? What kind of activities can we create where we're reinforcing good hygiene, and how do we have them reinforce those things at home? And that is actually one instance where one of my clients is like, well, can we take the temperature of the children before they come in? Reluctantly, yeah, you could. My preference would be that the parent, when they're dropping them off, the parent stays in the car, but one of the workers comes out, meets the child in the car and asks, I'm glad you're here. Has your son or has anybody in the household or has your child had a fever, any stomach aches, sniffly nose, anything like that? Okay, no, then come on, let's go ahead and bring it. And then the first thing they do is they squeeze some hand sanitizer on the kid. They do it, so they model it, and they bring the child in. I recommend face masks unless there's respiratory issues. So you're still doing those kinds of precautions. I have one company that does the tutoring, and they've been doing most of that online. They were still able to manage to do it. It's not necessarily as effective. As they're starting to bring people in, they're still going to do a lot of online stuff, but they're setting it up so instead of having 12 people there at once in a smaller space, they're going to have 3 people. And other people are going to be still doing some of the online. So they're not bringing everybody back right away all together at the same time.
Thank you. And so I guess, Rich, with
Well,
that, you can go ahead and wrap up.
Okay, well, let me ask one more question for Rob, because I think it's important. Do you think that an employer is obligated to bring back employees in any sort of an order? So my thought is, if an employer says, well, I'd like to get rid of a certain, let's say a group of employees, maybe the older employees like myself, and boy, so you know what? I'm going to just bring back the first half are going to be all the younger employees. And I may or may not bring back the older employees. It just seems to me that you have the potential here for some abuse in terms of discrimination as to how you go about rehiring or
I think we're going to see an increase in age discrimination claims and disability discrimination claims.
Yeah.
So you absolutely cannot make the decision, hey, this person's older, or this person has a medical condition that makes them comprise. So I, as the employer, am going to decide this person shouldn't work. That's not our decision. That's their decision. That's why we have the anti-discrimination laws in place. Nonetheless, it may be necessary to do some reductions in force. We want to bring people back, but it turns out we don't need the people. So we're going to apply the same rules we normally do. We start with, what are the business needs? What is the areas of work that we need to keep going, short-term and long-term, kind of what is our plan? And based on that, if we don't, if this is what we need, who are the employees with the skills to do those? And how do we decide which ones are the ones we want to bring back? If you're thinking age, or because this person has a medical condition, then we've got an issue. We always want to be able to identify specific, preferably objective things that is the basis for our qualification. This job requires an electrical engineer. So we're only bringing back the electrical engineers. Or this job requires knowledge in this area, or this particular employee can cross, this person knows this system, but can also do that. So we're going to keep that person. If you're going to use, we got to do cost cutting and we just need to get rid of a bunch of people, I would favor keeping the employees who have been there the longest. I mean, seniority is not a requirement, but it does count. At the same time, you may decide that you need to get rid of the people who are earning the most, so we can maximize their savings. Yeah. That tends to be the people who've been working the longest. So it can be a catch-22, but we want to have those objective things that it's not related to age, race, sex, national origin, disability, that we can identify. And I do recommend go through it with your attorney. Certainly if you're a bigger company, keeping in mind that if you, the California WARN Act can apply if you, I think it's over 50 employees are being let go within a 30-day period. Federal WARN Act applies if it's 100 employees, I think in a 90-day work period. I always have to double check it. So just keep in mind those can affect, although Gavin Newsom did do a relief from the California WARN Act if you follow certain protocol. So if it's 1 or 2 employees, not a big deal. But if you start getting into 30, 40 employees, talk to your legal counsel.
Okay, Anjali, may I go ahead and kind of wrap it up? We're getting very close to right on time.
Please do.
I guess I want to leave with first thanking Rob for doing this with me. It's been actually a little intimidating to look at what you have to consider in reopening your business. To be honest with you, it's pretty scary. I think what makes it a little more challenging and problematic is that we're in uncharted waters. I don't know what the courts are going to do on some of these things. Also, too, things may change. If we have another surge from Memorial Day or from the protests or whatever in the COVID thing, I mean, we may regress back to some of the more stringent procedures, if you will, or rules that we had before. So it's almost a day-to-day thing. There are sources, though, that you can look at. I didn't even know about the CDC site, and that's great. I also saw this morning that the California Chamber has put out a so-called return to work checklist. I don't know if you can see this. You won't be able to read it, but I was hoping it would come in and I could show you the list, but it hasn't come to me. When we get it, Anjali and I have talked, we'll make this available to any members of the public any members of the chamber that would like to take a look at it. And it's certainly, I think, a place to start. And when you have questions, you try to find the kinds of professionals that you can count on to give you the good advice. So I want to thank everyone for attending, and I hope we provided with at least some guidelines to use in this very unusual situation.
So thank you, Rich and Rob. We are really glad that you were able to join us today and share such valuable information with our membership and the public. And we are very grateful for that. So with that, I am going to end the webinar and ask everybody to visit our website and see when our next webinar will be coming along. So thank you all.